So, Ian, walk us through this case that, just let's start with, I guess, the present, and then we will work backwards and find out the history that underlies Neil Gorsuch and his, I guess, he wrote up, I think this might be his first opinion that he's written. That involves worker rights and involves forced arbitration. What is the case that was resolved this past week or so?
Sure. So it's this case called Epic Systems. It's a really serious blow to workers' rights. So the deal here is that what your boss can do to you now is your boss can say, I want to take away two important rights from you. The first is the right to sue me in a real court if I break the law. Instead, you can only go to a private arbitration system, and the arbitrators tend to be more favorable to employers than real courts are. And then the second thing I'm going to force you to sign away is I'm going to force you to give up your right to bring a class action lawsuit. So if my company is engaged in widespread violations that are impacting thousands of employees, the thousands of employees can't join together under one lawsuit in order to try to stop it. And your boss can also say to you, if you do not agree to this, you're fired. And so that's what the court just said. The court said that your boss can coerce you into giving up some of your most important rights, your rights to actually be able to haul your boss into court if they break the law. And that you really don't have a choice in the matter, because if you don't agree to give up those rights, then your boss can just fire you.
Now, we should say, too, and I think people, regular listeners of this program are aware of the dynamic as to why class action suits exist. You could have an action that, when pursued by the individual, is, from a practical standpoint, not worth it or really impossible to win, because you're an individual going up against a massive corporation many times that has lawyers on staff and massive budgets for these type of litigation. They will it's simply a war of attrition, and so therefore you join with other people who have been wronged by the same defendant, and then you amass the power and the resources to actually fight this thing. So now, let me just hit one other point. When you say you have no other choice, why do you have to work there? Would be what someone would say, right?
Well, yeah, that's certainly the argument you're hearing from a lot of conservatives. One response to that is that, most people can't afford to just lose their job today and, run around trying to find a new job tomorrow. But besides that, right now, about a quarter of employers use these forced arbitration and no class action agreements. But that was before the Supreme Court said that they're allowed. So now that the Supreme Court has legalized these illegal agreements, what's going to happen is, you're going to see them proliferate. Probably, nearly every employer is going to have them. There's already law firms that are trying to make money drafting these things for employers. There's even one firm that put up a little, fill in the blank internet form that you can use to get a do-it-yourself forced arbitration, no class action agreement. So these things, within a matter of time, you're not going to be able to find an employer. If I were a general counsel to a major employer, I would feel that I was ethically obligated to advise them to put one of these things in.
Yeah, it's so financially advantageous to them that almost their fiduciary responsibility to their board of directors and their shareholders would mean that you have to adopt something like this, right? Because it so often comes out in their favor.
Right. If you were an employer and your choice was being immune to the law or not being immune to the law, which one would you choose? And to be clear, in many cases, we're not talking about just shunting lawsuits into a different form. We're not talking about just having them be conducted a different way. We're talking about stripping people of their rights in their entirety. And here's why. Let's say that your boss steals $1,000 from you. For most people, $1,000 is a lot of money. Let's say like they refuse to pay you money that they owe you, or for some reason you are robbed of $1,000 worth of money that you have earned. You know how much it's going to cost you to go to court to get that $1,000 back? It'll cost you a whole lot more than $1,000. You're not going to find a lawyer who's going to take the case on a contingency fee basis, because 30% of $1,000 isn't worth the amount of time the lawyer is going to have to put into it.
Right.
That lawyer is probably going to charge you hundreds of dollars an hour for their service. So you are not getting that $1,000 back. And the reason you're not getting the $1,000 back is because it costs more to get it back than than you have to stand to gain if you win the lawsuit. What class actions do is, if your boss is stealing $1,000 from everyone, if you have widespread wage theft, then all of you can join together. And if it's a company with 1,000 employees, suddenly that's $1 million lawsuit. And with $1 million lawsuit, you can get a really great lawyer. That lawyer's going to work on a contingency fee basis. It's not going to cost you that much to litigate it. And all of a sudden, you've got a real chance of vindicating your rights. So the reason why employers want to get rid of class action lawsuits is because without class action lawsuits, it's not just that, like, they don't have to deal with big lawsuits. Often they don't have to deal with any lawsuits, because unless they are stealing tremendous amounts of money from you, I mean, maybe if your employer refuses to pay you $100,000
right.
that they owe you, it becomes, cost effective to bring a lawsuit. But it really has to be a lot of money on the line before it makes financial sense to sue someone.
So, okay. So this ruling, Epic Systems, has the effect of basically barring the courtroom doors to individuals, because they can't get together as a group. And like you've just outlined, it's just sort of not cost effective. And what are the implications for labor law? Like, what does this do in terms of the National Labor Relations Board? Is it basically say that, that there's no room to legislate? Is this a statutory finding? I mean, what are the implications on labor law, sort of more broadly speaking?
Right. I mean, the implications are tremendous here, because, what's so scary about these forced arbitration cases and these no class action cases is they're not just about disabling one law, they're about disabling every law. So if your employer forces you into one of these agreements, it's not just that you can't sue them if they don't pay you the minimum wage, or you can't sue them if they don't pay you overtime, or you can't sue them if they violate their employment contract, or potentially you can't sue them if they fire you because they don't like their skin color. It's not just one of those things. It's all of those things. I mean, that's the point of these contracts, is it applies to any dispute that you have with your employer.
All right. So when we got to take a break. When we come back, let's talk about the sort of the history underpinning this, and the push for a guy like Gorsuch. And frankly, it seems to me at this point, 5 of the justices on the Supreme Court, to put us back into a Lochner era setting. And you'll explain what that means when we return. I'm Sam Seder. This is Ring of Fire Radio. I'm talking to Ian Millhiser about Epic Systems, a case adjudicated by the Supreme Court this past week, and one which is going to have huge implications for labor law in this country.